political activities as we all are preparing for the local government elections. We've just came back from the open voter registration last weekend. We know it's been a busy recess, but welcome back. We are taking our legislative program aggressively. We all will recall that we would have had a piling up legislative program, which was caused by the work of the ad hoc committee. But we're back now. We are welcome to the meeting, all of you. Committee Secretary, do we have apologies?
Good morning, Chair and honorable members. There are no apologies from my side.
Thank you. DM?
Chair?
Chair, thank you very, very much. No, just the apology of Minister Mameloko Kubai. She is unwell and therefore, unfortunately, not able to attend. She conveys her apology.
Thank you, DM. Committee Secretary, you were saying something?
Chair, actually, the Deputy Minister has covered me.
Okay. Also, Honorable Swart has indicated that he is going to be in and out as he has got a number of meetings to attend to. Members, I am also preparing for a funeral. I'm at home. Can I request humbly, with your concurrence, that Honorable Matafa proceeds with the meeting?
That should be in order, Chair. And we condolences to yourself and to the family.
Thank you so much, Honorable Manyi. Members, I guess there is no different view. Thank you so much, members, and thank you so much for understanding the situation that we find ourselves in. Mr. Matafa?
Thank you very much, Chair. Good morning, Chair, and let me join Honorable Manyi in passing our condolences to you and the family. We wish that everything goes according to plan. Thank you, Chair, for this opportunity. Let me greet members, the Deputy Minister and the team from the department. Honorable members, we are gathered today to receive a briefing from the department, which relates to the SAJEI bill. And we know that our primary responsibility is passing legislation, but also we will look at amendments. And as we have received the correspondence that is coming before us, or maybe before we go to the correspondence, let's reflect on the agenda that is being flighted. The first part was apologies, the Chair would have covered that particular part. And the second point will be correspondence. I see the name of Honorable Manyi has been put on, and there's information regulator, which is stated as anonymous. I believe that Mr. Ramano will assist in that particular regard. And then on item 3, we'll receive a briefing by the Department of Justice and Constitutional Development on the SAJEI bill. And then item 4 will be the public hearings on the same bill. And we would have received correspondence from Democratic Governance and Right Unit and Helen Suzman Foundations. Honorable DM, your hand is up. Is it a new intervention or is it a legacy hand?
No, it's a new hand. And maybe in the language of yesteryear, when I was still a member of the ANC Youth League, I would call it a point of before. Chairperson, my sincere apologies. I should have, under apologies, also indicated that regrettably I would need to leave by 10 o'clock. I don't do that lightly, but I think as the chairperson had indicated, we are preparing for local government elections, and there is a special meeting of the IEC National Political Liaison Committee, which will be entertaining the matter of the election timetable. So my request would be, if at all possible, and if it's not inconvenient to the committee, that we start with the briefing by the committee on the SAJEI bill. And I also want to convey my condolences to the chairperson and his family. Thank you.
Thank you very much, Honorable DM. Members, there's a request from the DM that maybe we move the item 3 to become item 2, and then item 2 become item 3. I see Honorable Manyi has been listed under item 2. Can I check with Honorable Manyi if that is in order?
No, Chair, it's not in order. Because the correspondence relates to things that I would have actually preferred the minister to have been here. In the absence of the minister, I think the DM should hear the matters that are in that correspondence.
Honorable Ramano, Mr. Ramano, can I check if whether you received the correspondence and how long is the correspondence? Is it a matter that we can process within the next 20 minutes before the minister leaves?
Chair, I think will be entirely in Honorable Manyi's hands, but the correspondence was shared by Honorable Manyi in our WhatsApp group. So maybe can just give you an indication as to how much time he needs.
5 minutes.
5 minutes. I think that 5 minutes would be sufficient. DM, is it okay that we allow Mr. Manyi to lead us on that item? And then when we get to the presentation of the bill, you can do opening remarks and hand over to one of your team members from the department to lead the discussions.
Chairperson, thank you very much. That's perfectly in order.
Thank you very much, DM. On item 2, under correspondence, we would have then received correspondence from Honorable Manyi. Can I open the floor and invite Honorable Manyi just to lead us on that particular item? Honorable Manyi?
Thank you, Chairperson. Let's get this right here. No, Chairperson, I have written a few correspondence which brought to the attention of the committee, and I'm requesting that the committee process that correspondence, and also there are matters there that I think they require immediate parliamentary oversight. I accept that some of the issues may have been overtaken by events, while others may have recent developments. The first issue, Chair, I've put in that correspondence is the issue of that the retired Hawks Colonel, Kobus Rulofse, told the Madlanga Commission under oath that Advocate Andre Johnson shared or facilitated the sharing of the complainant statements, the J88 medical report, and an audio recording with Major General Khan before he made his warning statement. That submission has not been contradicted. So that is actually 101 interference with a criminal investigation, which amounts to defeating the ends of justice. Advocate Johnson herself has confirmed that a criminal docket has been opened against her, but there's been no further progress. So, Chairperson, the point here is that the independence of the NPA is not a license for indefinite delay. So I'm calling for the accountability by those with the levers of power in terms of our constitution, and for this committee not to be a helpless bystander. The docket must be finalized and Advocate Johnson must be brought to book. That's the first issue. Secondly, Chairperson, on the 16th of July, the MK party called for Advocate Johnson's suspension pending a fitness inquiry. The NDPP acknowledged receipt, no inquiry followed. Instead, on the 27th of July, the president hurriedly, I must underline this, hurriedly accepted her resignation with immediate effect on a 24 hours notice before any inquiry could begin. So as the MK party, we contend that resignation from accountability should not be condoned. So I asked the minister whether she recommended or supported that decision, and if so, on what basis, given the scary revelations at Madlanga Commission? Why was she not suspended and put through an inquiry process like Advocate Chauke? Or, in fact, is that process reserved just for Africans? I wanted to put it to the minister if she was here. I'm hoping that the deputy minister is here. That if no accountability measures are brought in the interest of justice, then South Africa has just witnessed the great escape, a resignation engineered with such haste that it insulated a senior official from scrutiny and accountability, with the minister and the president as its facilitators. It's a very sad observation, and I'm hoping that I'm wrong. Thirdly, Chairperson, we also wrote a correspondence on the 21st of July in support of our earlier submission. That correspondence sought to clarify an objection to the appointment of Judge Raulinga as IDEC oversight judge. We make no allegations of actual bias. We apply simply the Constitutional Court's own test, which is reasonable apprehension of bias. We put it no higher than that. And all of that based on the facts that Judge Raulinga himself placed on record, twice, 11 years apart, a friendship with a senior ANC political figure, no less than the head of state, spanning roughly 4 decades. How can anybody really in their right mind pretend that there can be an apprehension of bias in a situation like this? We are saying, Chairperson, that those facts alone give rise to an objective, reasonable person's apprehension of bias. It is our submission as MK Party that that appointment was therefore a serious error of judgment, one made worse by what IDEC itself exists to do. We contend that IDEC was established in part to shield criminal justice institutions from political interference. The legislation requirement that the oversight role of IDEC be by a retired judge was not just some statement. It was a deliberate qualification to ensure impartiality. But for the minister to appoint as his oversight role a judge that has publicly brandished a 4-decade friendship with the head of a governing party does not shield IDEC from political interference. In fact, it actively invites reasonable perception of it. This appointment should never have been made without far greater caution and due diligence. And we contend that this committee is entitled to make these comments, and that this appointment should in fact be reviewed and set aside. That's our submission. And as I learned, Chair, that this appointment does not also stand alone, Chair. It is mired in further controversy, one that compounds rather than mitigates the concerns that have been raised just now. Just to remind you, Chairperson, on the 6th of November, 2025, Advocate Johnson told the ad hoc committee that the minister appointed Judge Raulinga on the 11th of October, 2025 for a 5-year term. We still don't know even what happened to that part of the submission. But putting that aside, based on the minister's own version as given on the 3rd of December 2025, that submission by Advocate Johnson was actually false. We argue that if Advocate Johnson's evidence was false, why has the minister not referred the matter for investigation into whether perjury may have been committed? The minister pointed out that Section 22, capital A, which establishes that office, would come into operation on the 1st of March 2026. No such appointment could lawfully have existed on the 11th of October, even if Advocate Johnson insists. On the 3rd of December, the minister herself told Parliament emphatically and insipidly, for emphasis, that Judge Raulinga had not yet assumed duty and that she had not received a single invoice from him. We therefore say, Chairperson, that submission alone by the Minister raises another question. If Judge Raulinga did not submit an invoice, what then was it doing at IDEC that created the impression for Advocate Johnson that he was already on duty? What was it doing in those buildings? What was it doing before the 1st of March there? What legal instrument placed him there in the first place? So the minister then announced the office's operationalization on the 10th of July in the press, some 4 months later, after the Gazette of the enabling regulations. So the question is, what was that just a public relations exercise for an office that had already failed to assert its presence from 1st of March 2026 or even earlier? So not sure what purpose was being served by that 10th of July presser, given that the regulations gave effect to this position on the 1st of March already. So, Chairperson, there's nothing around this office that inspires confidence. So I want to appeal that, in fact, Judge Raulinga himself, as a man of honor, he should just walk away from this. It's going to tarnish his very great record in the judiciary. So as I learned, Chairperson, we're saying these are not isolated complaints. They reveal a disturbing pattern. Institutions established to combat corruption appearing to operate outside the very legal framework they're entrusted to uphold, and they're protected at the very top by the officials meant to hold them accountable. We request, Chairperson, that all these submissions be formally received and processed. We request that the minister appear before this committee or furnish a full written response within 7 days and account for her role and the presence in accepting Advocate Johnson's resignation ahead of an inquiry. We request that this committee obtain urgent report from the Hawks and the National Director of Public Prosecution on the status of the criminal docket and the reasons for the delay so that Parliament can satisfy itself that justice is being pursued without fear, favor, or prejudice. We request the necessary oversight engagements, Chair, should be scheduled without any further delay. That's my submission, Chairperson. Thank you very much for your indulgence.
Thank you very much, Honorable Manyi. Members and colleagues, those are the correspondence that were received from Comrade Manyi, from Honorable Manyi, I beg your pardon. And as such, they are formally before the committee and they are received and they will be formalized. DM, would you want to maybe make input based on the submission, taking note of the requests that Honorable Manyi makes to be specific in terms of how he's requesting the committee to be and into the confidence of the minister and the department?
Yeah. No, Chairperson, thank you very much. I think we take note of the matters raised by the Honourable Manyi.
I think, Chairperson,
we are not privy to
DM, my apologies. I beg your pardon. I hear the voice of Comrade Musala. Comrade Musala, do you want to come in?
Can you please allow us to speak before the DM can come? Maybe you did not see.
Fine. I did not see your hand. I apologize. Can I also note, members, are there any member who wish to take a bite at the submission by Honorable Manyi? Noting Honorable Musala first.
No, thanks so much, Chairperson, Acting Chairperson Honorable Oscar Matafa. Let me take an opportunity and greet the members of the Portfolio Committee, the DM. Chair, I think if what Honorable Manyi have presented here is correct and is factual, as the committee, we need to fight against that. The issue of Judge Rauling, we came here as the economic freedom fighters and we asked these questions to the minister, and the minister's response was, as Honorable Manyi have highlighted, we need to understand exactly the criteria used to hire that, to put that man Judge Rowling as the appointed to lead IDEC for now, in the absence of Advocate Johnson, who have just resigned. We were very skeptical even before, and the question, the answer from the minister was also very, it was just, it was not straightforward. And we felt like there's something that she is protecting, or she doesn't want to say to the portfolio committee. Now today, after the president have accepted the resignation of Advocate Jensen, we see this Judge Rowling, who has a very close relationship with President Ramaphosa, who in public, in many ways, have already stated that is now acting there as the head of IDEC. We see it as a way of protecting certain things that they don't want the public to know about, or they also don't want accountability in many ways. So can the minister, I support what Honorable Mani have spoken about here. Can the minister come forward and explain exactly what is happening, so that we can all be on the correct page, or on one page? Chairperson, the issue of the resignation of Advocate Johnson is really very worrisome to us. It seems like every person who has to face accountability, the person, those just come and resign. And we are requesting that this portfolio committee must hold those people accountable. We must never shy away for holding them accountable to escape the route from accountability. We must make sure that the criminal justice system institution depend on the principle that every official, regardless of rank or political proximity, must account for their conduct. So the things that were proven there in Matlanga Commission is not just small things. So the advocate must account. Anyone who go wrongs, the EFF doesn't support any corruption. If you do things in your own way, so you need to be held accountable. We need a country that is free from those things of corruptions and everything, so that this country can be restored. I'm not going to waste a lot of time, Chairperson. I think I will end there, but that one of Rodling, let the minister come forward and explain. But the DM is here, I think he can also give us an answer, but because the response on that day was done by the minister must come and share this thing with us. It seems like it's been staged here, where they tell this one, go resign, and this one comes in. This one will have capacity to pretend to protect whatever it needs to be protected. Thanks so much, Chairperson. I'll pause there. Thank you.
Thank you, Honorable Musala. Honorable Breitenbach.
Morning, Chair. Thank you very much. And good morning to everybody. Chair, yes, we to a degree support the submissions of Honorable Mani, one or two of them perhaps not quite so strongly as what he suggests. But we do think that that the committee needs to be updated, and that people need to be held accountable. So in general, we support that. Thank you, Chair.
Thank you very much, Honorable Breitenbach. Can I please invite Comrade Tsotetsi, Honorable Tsotetsi?
Well, thank you, Chair, and good morning to all members of the committee and everyone else that is in the platform. Chair, we note the submission of Honorable Mani. I think that it's correct of him to demand response in 7 days. It's well within his right to exercise his responsibilities as a member of parliament and a member of this committee, but on a separate request for these matters to be perhaps ventilated as a committee, we may want to schedule a session with IDEC so that we're able to put across matters that we would want to put with IDEC. And I hope that in that meeting, we will then have the minister present to say over and above responding to these specific matters. We are also given space to deal with the broader health of an entity, which is IDEC. For now, the matters may be treated as the submissions of Honorable Manye, which requires a very direct response to him. And as part of the program of this committee, schedule a separate date wherein we will be able to deal with the broader health of IDEC as an entity. That would be my submission, Chairperson. Thank you very much.
Thank you, Honorable Sotetsi. Honorable Mkongi.
Thank you very much, Chairperson. Can you hear me?
Loud and clear, Honorable Mkongi. Please proceed.
Thank you. As Umkhonto says, we support that submission wholeheartedly. And we propose further that not the deputy minister, the minister must come and explain about the actions that they have taken by the ministry on this particular matter. But in emphasis, we are saying that we support that and we want to canvass the whole committee to support the submission of Mkhonto Wesizwe Party. Thank you very much.
Thank you, Honorable Mkongi. Mr. Ramano, you'll help me if there's other hands that I would have missed. As far as I'm concerned, this would have been the last hand. Before the DM comes in, it is quite clear that there is consensus in the committee that the submissions made by Honorable Manye are sound and they require processing as a committee. As much as they are Honorable Manye's submissions, there's consensus that they need treatment and treatment through this particular platform. So there are certain questions that will arise, and I will request Mr. Ramano to assist us, even though administratively not necessarily here. Mr. Manye addresses his concerns and requests to the Ministry of Justice, but equally there are certain of his concerns that touches the presidency and the decisions taken by the president. So in terms of how this correspondence is processed going forward, I'll request Ndada Ramano to guide the committee, and that can be done administratively. But as a committee, we accept the submission as formally presented to the committee, and we align with the views of the committee that processing of these submissions is important. Honorable DM, that is the position of the committee based on the submission. Can I request that maybe you make inputs where necessary, and then the process will unfold as I would have alluded to a moment ago. Honorable DM.
Chairperson and honourable members, thank you very much. I think we've heard the submissions of the Honourable Manye very clearly, the issues that he has outlined and the views of other members of the committee. I think it is within the rights and, in fact, the duty of Parliament to do that oversight work. We do request that the matter be processed within the committee and that all of the relevant documentation and the questions that have been raised be forwarded. I think these are matters of tremendous public importance and feature prominently in our national discourse at the moment. And therefore, I think it would not be appropriate to give immediate answers to matters that should ideally be responded to with should receive considered responses and preferably also in writing. With that, thank you. I will also convey to the Minister the sentiments and the issues raised by the committee. Thank you.
Thank you, Honorable DM. I think that exhausts item 2. I also see an indication of happiness from Honorable Mani. So I think that we can move away from that item and move to the item on the South African Judicial Education Institute Bill, an institution that plays a critical role in developing a competent and ethical and independent judiciary. So DM, without further ado, can I invite you to make opening remarks before we start deliberations on the bill?
Chairperson and honourable members, thank you very much. Very good morning. I just want to state that on the platform we also have Advocate Potgieter, the Acting Secretary General of the Office of the Chief Justice, Dr. Shamase, the CEO of the South African Judicial Education Institute, Advocate Tipanyani, Chief Director in the Office of the Secretary General, and Advocate Nelson Pakola, a Principal State Law Advisor. Furthermore, we have with us Advocate Steve Ralekwa, the Acting Deputy Director General for Legislative Development, and also Advocate Tsietsi, who's the principal drafter of this legislation and who will do most of the presentation. I think as I said, the officials will shortly take the committee through the detailed provisions of the bill, and therefore I'm going to confine myself to really the broader policy significance of the bill and its place within the long-term constitutional evolution of our justice system. And I think it's significant that this legislation is being introduced in the year that we celebrate the 30th anniversary of the adoption of our Constitution. We do so under the theme, One Constitution, One Nation, Reflect, Renew, and Recommit. And I think it serves as a reminder that the Constitution not only established a new legal order, but it also outlined a vision of the state founded on the separation of powers, on judicial independence, accountability, and the rule of law. So building the institutions that are required by that constitutional vision has been a gradual process. It's unfolded over the past 3 decades through a succession of reforms that have been aimed at strengthening the independence, the effectiveness, and the legitimacy of the judiciary. We think back to the establishment of the Office of the Chief Justice as a national department in 2010, the designation of the Chief Justice as the head of the judiciary, the enactment of the Superior Courts Act, and the creation of the South African Judicial Education Institute, and the progressive transfer of judicial functions from the executive to the judiciary have all formed part of that constitutional journey. And I think this bill represents another important step along that path. Its immediate purpose is quite modest. It restructures the governance arrangements of SAJEI by distinguishing more clearly between its academic leadership and its administrative management. It creates the position of a dean, who must be a judge or a former judge, a retired judge, who will serve as the academic head of the institution while clarifying the role of the executive director as the administrative head. So at one level, these are governance amendments, but at another level, they do reflect an important constitutional principle, that judicial education is not simply a matter of public sector training function. It's very integral to the independence, the quality, and the integrity of the judiciary itself. Because the education of judges and the development of judicial ethics, the strengthening of judicial leadership, and the cultivation of judicial excellence are matters that should increasingly be shaped by the judiciary itself. And for that reason, the bill provides that academic leadership of the institute should rest with a serving or a retired judge. It strengthens judicial ownership of judicial education while retaining sound administrative governance and public accountability through the executive director and the council. Now, Chairperson, I think this must be seen as part of the commitment by government to pursue a long-term objective of creating a single judiciary operating within a judiciary-led court administration system, consistent with the constitutional vision reflected in Schedule 6 of the Constitution. Now, this commitment has been reaffirmed by President Ramaphosa, by Minister Kubai, and through our ongoing engagement with the Chief Justice and the heads of court. And I think importantly also to add, increasingly, the leadership of our district and regional courts, the magistracy, consistent with the injunction of a single judiciary. So that movement towards a judiciary-led court administration model is not an event, it is indeed a process, and it's a very exciting process, but also one that is quite complex and that brings to the fore many fundamental constitutional imperatives. On the one hand, the independence of the judiciary; on the other hand, the requirement that all who hold public office must be accountable for the use of resources and the actions that they perform. And how to structure that in a way that meets both of those imperatives is something that forms an ongoing dialogue between the executive and the judiciary, and those issues came to the fore quite strongly at the recent judiciary conference that was held in eThekwini a few weeks ago. And I think it requires very careful institutional development, it requires appropriate governance arrangement, and it also requires capable institutions and it requires the judiciary to assume increasing responsibility for those matters that are closely connected with the exercise of judicial functions while preserving proper constitutional accountability for the use of public resources. And I think judicial education is one such function. The bill therefore supports not by a dramatic constitutional change, but through careful institutional reform, that continued maturation of South Africa's constitutional democracy. It strengthens the institutional capacity of the judiciary to educate its own members, to develop future judicial leaders, to respond to new areas of law and technology, and to ensure that judicial officers continue to uphold the highest standards of constitutional jurisprudence. We want to give the committee the assurance that and to emphasize that these amendments did not originate within the executive. They emanate from the council of SAJEI itself and following recommendations of a subcommittee that was chaired by the Deputy Chief Justice. And therefore, the bill also reflects a collaborative process between the judiciary and the executive undertaken in the shared interests of strengthening one of our key constitutional institutions. And I just want to, again, to avail myself of the opportunity to really commend the leadership both of council and the current executive, current and former executive director for the ongoing excellent work being done by SAJEI. Chair, I conclude with two remarks. The one is just to express our appreciation to the Portfolio Committee for the very vigorous focus on the processing of legislation. We have in the past also expressed our concern that members of the Portfolio Committee have been given other onerous duties, important national duties, that have impeded their ability to pay attention to legislation, and we're happy to see that is being attended to. But lastly, that just to emphasize some of the points that I made earlier in my opening remarks, that we are at a juncture where we are at an advanced stage of engagement with the judiciary around what the framework of a judiciary-led court administration model should be. There are, however, quite a number of complex issues that all of us collectively are grappling with. And our appeal to the committee would be just to be sensitive and to be mindful of those developments so that we treat whatever governance arrangements and accountability arrangements in respect of SAJEI as a integrated whole with that process of moving towards a judiciary-led court administration model, so that we don't inadvertently perhaps end up with lacunae in our systems of accountability in respect to the work of SAJEI. Chairperson, with that, thank you very much. I would then like to hand over to Advocate Steve Ralekwa and Advocate Tsietsi Sibelemecha to take the committee through a detailed presentation. And I once more tender my very profound apologies for not being able to stay. I will rejoin the committee once the other meeting is finished, if the committee is still sitting. With that, thank you very much. And Chairperson, with your permission, if Advocates Ralekwa and Sibelemecha could take the committee through.
Thank you very much, DM. The team can proceed.
Good morning, Chair. I'm at Tsietsi Sibelemecha. Mr. Ralekwa, I just indicated that he lost connectivity, but he's trying to join back. If I may be allowed to proceed, I'll also request that my video, I remove it. We've got a bit of network challenges. Thank you, Chair. I had requested that I be assisted as well in terms of the flighting the presentation. If I don't know if Mr. Ramano and the colleagues from the ODG have already communicated and shared the rights to be able to flight.
Mr. Ramano, can you assist, please?
Chair, Ms. Maslangu from the department will flight the presentation.
Thank you very much.
Thank you, Chair. Yeah, we can start with I think we can just skip the first 3 slides, which basically are simply saying what is the purpose of the briefing. The third slide, yes, we can start there, which talks to a bit of the background, but the third slide. Yes, thank you. I think this is not the right presentation. This is not the right presentation. We need the one for SAJEI. This is the one for JMA.
Is Ms. Maslangu able to hear you, that you are requesting for a different presentation?
I'll call a Chair. Thank you.
Thank you very much.
The wrong one.
Yes, thank you. We can just go to the third slide. The Chair and honorable members, the DM has already given the background in terms of where the amendments emanate from, and the purpose of the bill, I'll maybe start from there, is to just provide for the appointment of a judge as a dean to serve as the academic head of the institute, and the DM has also indicated that the background to it in terms of the establishment of the institute. And as well, we are also providing for the functions of the dean, and also clarifying the regulation of appointment, powers, and duties of the executive director, who's currently referred to more as a director of the institute, and as well dealing with the issues of reimbursement of the members of the institute for their traveling and subsistence expenses. Next slide. The bill itself, in clause 1, we're just dealing with the definitions where we define the term dean, and as well replacing the definition of a director with that of executive director due to the changes. And as well in clause 2, we are amending section 7 of the act, as we call it the principal act, so that we are able to add the dean as a member of the council. And in clause 3, we dealing with section 11, wherein we are replacing just technical amendments director with executive director. And as well in clause 4, we then dealing with section 12, wherein we are making a provision regarding the appointment of the executive director. And here we're dealing with more the terms and conditions as may be determined by the council. Then in clause 4 again, we just dealing with what are the responsibilities of the executive director, being the administrative head of the institute. And some of the functions, as we mentioned there, is to manage and direct the activities of the institute, to appoint and supervise the administrative staff, and as well as to ensure that the quarterly management reports are submitted to the Secretary General. The annual report is then collated and submitted to the minister. And the act, wherever it says these are the functions of the executive director, it is upon the executive director to perform those duties that are elsewhere in the act. Next slide. Then the clause 5, then we are introducing new sections which are going to be 12A and 12B. And in 12A, we are dealing with the appointment of the dean, as indicated, who's a judge, and will be appointed by the council. And the judge in active service may only be appointed after consultation with the president of the SAJEI or a judge president of the respective or the concerned high court that will be seeking appointment from or having designated a person to be appointed from. And the term, it will then be 5 years, which are non-renewable. And as indicated earlier, the dean will be the academic head of the institute. Then in section 12B, that is to be new, then we're providing that the dean, as responsible for the general academic program, will, amongst others, be responsible for the following: providing a broader academic strategic vision of the institute and supervising all the judicial educators, designing and developing the academic agenda of the institute, and as well the responsibility to consult with all the heads of court on any training needs that they may have, and as well directing, controlling, and coordinating the research aspects. Next slide. Then moving on to clause 6, Chair and honorable members, section 13. In section 13, we're dealing with the consequential amendments of replacement of the term director with executive director. Then in clause 7, we're dealing with section 14 in order to clarify that the remuneration of the members of staff should be consistent with those that are paid in the public sector. And in clause 8, we're dealing with section 15, wherein we are amending it to require that the executive director should, in consultation with the dean, prepare and submit an annual report to the council for approval. And subsequently, that report must be submitted to the minister within 6 months after the end of the financial year for the institute. And clause 9, Chair and honorable members, are amending section 17 to provide for the reimbursement of members of the institute who are office bearers in respect of their subsistence and traveling expenses in the performance of their functions. And the clause further provides for the payment of remuneration, which would include allowances for subsistence and traveling expenses that would have been incurred by any member of the institute who is not an office bearer. And lastly, Chair and honorable members, clause 10 contains the short title and the commencement provisions. I think that is the end of the presentation, Chair and honorable members. Thank you.
Thank you very much, Mr. Sibele Major. Members, that is the presentation. Can I note hands of members who may want to seek clarity or interact with the presentation? I see the hand of Honorable Klopper. Are there any other hands?
Struggling to raise my hand here, Chair. Please note mine.
Mr. Mani will come after Mr. Klopper. Any other person? For now, can I invite Honorable Klopper?
Chairperson, I just want to find out, would it be appropriate to comment in this time, or would you want to have all the other presentations done first? And we asked holistically over the two presentations with the inputs.
I'm comfortable either way. Can I check with members? Would members be comfortable to take other presentations so that we interact with all of them at a go?
I'm easy, Chair. But,
You're okay.
Yeah, I'm easy, although they are distinct. But if it's gonna make life easy for the other member, I'm easy.
Okay, in that case, I think we are fine. I had only two hands of Honorable Klopper and Honorable Mani. Both are easy that we can take all presentations that are related to today's meetings. Can we approach it that way and take the next item on the same matter?
That would be appreciated.
There's another hand of Honorable Tiamo, Chair. No, you don't see these hands here.
Thank you very much, Honorable Mani. Honorable Zotezi?
The hand was to speak to the presentation. I think it's I'm content. We can take other presentation. Will come in later.
Okay, perfect. Honorable Ramano, Mr. Ramano. Mr. Ramano?
The next presentation, I am not sure if it will be Mr. Benjamin or one of his colleagues, but they are on the platform.
Yes, we are present and I'll be doing the presentation, Mr. Ramano.
Thank you very much, Mr. Benjamin. Please proceed and welcome.
Thank you very much, Chairperson, and thank you very much, honorable members. My name is Mbegazeli Benjamin, and I come from Judges Met. I'll do the presentation on behalf of the joint submission that the DGRU and the Helen Suzman Foundation have submitted. Firstly, just good morning to you, Chair. Good morning, honorable members. Good morning to colleagues in the Department of Justice and in the Office of the Chief Justice and others who are joining us this morning. So our submission on the SAJEI bill is really to highlight some of what we thought were questions in terms of what the bill aims to do and how it is drafted. We are basing these submissions on what we see from the memorandum that was submitted alongside the bill. So the memorandum is very good at telling us what the bill does, but it doesn't really explain why. So some of those questions that we ask are addressing those kinds of why questions. Chairperson, I have a presentation and I don't have flighting rights. I'm hoping Mr. Ramano may assist with the presentation, or at least give me permission to share the presentation.
Mr. Ramano, can you please assist? You have been given the rights. Please just check and proceed.
Oh, yes, now I do. Thank you very much. Okay, so like I mentioned, the joint submission is between us as the Democratic Governance and Rights Unit, which Judges Matter is a part of, and then the Helen Suzman Foundation. And a little bit about us. We are the Democratic Governance and Rights Unit. We are a research unit at the University of Cape Town, and we focus on the judiciary in South Africa and in other African countries. So we focus on judiciaries in Africa. And then the Helen Suzman Foundation is our partner organization on this specific submission, and they do similar work in terms of focusing on the judiciary and the rule of law. Just a broad outline of the presentation. I'll speak to some of the aims of what we could get from the SAJEI bill. And then Chairperson, I'll speak to just 6 topics that we will raise as a concern that we're hoping that the committee will consider in its drafting of this specific legislation. And those topics are, number 1, the mismatch between what we see in the SAJEI Act, so the existing act, and what we see in practice. How we understand the role of the dean within the broader institutional architecture of the SAJEI and the Office of the Chief Justice. What we see also between the role of the executive director and what the bill suggests and what is happening in terms of accounting for SAJEI's operations. And then we also raise a question about the role of the dean in relation to magistrates, because as the bill is currently written, it speaks about judges. And so we wanted to ask a question about that. And then we also wanted a question, we had a question about accountability and possible removal of the dean before the end of the 5-year term. So these are the issues that I'll speak to in the presentation. And just to give a little bit of context to SAJEI, what we understand SAJEI to be. SAJEI was established in 2011 as South Africa's standalone National Judicial Training Institute. So the creation of SAJEI was part of a global trend of trying to create standalone institutions that will offer judicial training. In fact, if you look in the continent, in Kenya, the Kenyan constitution establishes a judicial training institute for their judiciary, and that is called the Kenyan Judicial Academy, and it is a standalone institution with its own council, officials, its own building where it does the training. So SAJEI's mission really is to be a national education, research and training institution for the judiciary. It's there to promote the values of the Constitution, including the independence of the judiciary, the accessibility, the integrity, the accountability. So some of what the Deputy Minister spoke about earlier about ethics and the role of training for ethics, that's what SAJEI is also meant to assist with. And then SAJEI provides training to both aspirant judicial officers and also those specifically who are newly appointed. So judges and magistrates who are newly appointed undertake SAJEI training. And then obviously experienced judicial officers are given training on latest developments in the law. And there's also an aspect where SAJEI is supposed to provide research on judicial education and also other responsibilities, both locally and internationally. And then the structure of the governance of SAJEI. So it is governed by a 24-member council. The council is chaired by the Chief Justice. The majority of the members of the SAJEI Council are judges themselves. It has about, judicial officers, that is. So there are 9 judges, 5 magistrates, 4 law professors, 2 legal practitioners. The Deputy Minister of Justice is obviously a member representing the executive. There's also a member of Parliament representing the national, representing the legislature. Currently, he's the member of the National Assembly. It's Ms. Fasia Hassan. And then there's also a member representing the National House of Traditional Leaders on the SAJEI Council. And then just to speak a little bit about the structure of the council itself, it has subcommittees that carry the different aspects of the work that it does. So there is an executive committee chaired by the Deputy Chief Justice. There's the Curriculum Development Committee chaired by a retired judge currently, Judge Luo. There's a Budget and Finance Committee chaired by President Mulimela of the Supreme Court of Appeal. There's the Human Resources Committee, which is chaired by Judge Steyn of the KZN High Court. So the council is supposed to be responsible for the governance of the institution. And that's why even in the bill currently, there are key parts where the council is given that responsibility, for example, of hiring the executive director, of hiring the dean. And so that's where this fits in. And then in terms of the mandate, what we glean from the legislation itself and what we've seen from practice, Chairperson, honorable members, when you read the SAJEI Act, as it's currently written, when you read it from just page to page, the image that comes to your mind is of an institution that is there to provide education for the judiciary. So you visualize classrooms, you visualize lecture halls, seminar rooms, presentations, activities, assessments. That's the picture that you see in your mind when you're reading the legislation, and that is true. That is often what is happening at SAJEI. So there is training for judges, training for magistrates. There's even training for traditional leaders when it comes to the rollout of the Traditional Courts Act. So that is what we see from having interacted with SAJEI in different spaces. And then there are also the flagship courses that SAJEI does. So the Aspirant Women Judges course, it has now been running, I think, for 22 years. It has actually been one of the most instrumental courses to enable transformation of the judiciary. So many of the women judges who've been appointed at all levels of the courts have come from the Aspirant Women
Mr.
Judges
Benjamin,
course. Yes,
my
Chairperson?
apologies to come in. I'm not sure if whether is it the intention or you are still going to switch the presentation on, because on the screen we have you, but not your
Really?
slides.
Oh my word, that
Yeah, please, if you can just assist us in that regard. Thank you. My apologies for intervening like this.
Oh no, but thank you very much, Chairperson. In my mind, I was thinking that the presentation is there. Can you see it?
From my side, it is still you on the screen.
It's still me.
Again, please. Yes.
Oh my. Is any
There we
still,
go. There we go. Yeah, the presentation is up. Thank you very much, sir.
I really apologize, Chairperson.
Not a problem. Thank you so much. Please proceed.
Okay. So I had spoken quite a bit. So I'll just quickly recap. I was just speaking broadly about the context and the mandate of SAJEI and what we understand it to be. And I was speaking right now about the Aspirant Women Judges course, which I mentioned it adds in terms of transforming the judiciary, especially when it comes to women's representation on the judiciary. And of course, one of the two other flagships are the new magistrates training and new judges training. So, Chairperson, I'm just sketching the context to understand where these amendments fit in when you will have finalized the bill, and also to contextualize some of what we are picking up as maybe concerns that we would want the committee to clarify, working, of course, with the department, both the DOJ and the OCJ. And then another important aspect of SAJEI, from what we got from the 2024-25 annual report, is that there are about 20 staff members on its organogram, including the CEO, project administrators, and judicial educators. The operational budget, it's about 31.7 million rand. And then in 2024-25, they offered about 141 courses, and they indicate that most of those are virtual, and about 3,745 participants were reached in those courses. So the point here, Chairperson and honorable members, is that SAJEI is quite a complex operation. It is comparatively on the continent, it is one of the largest and probably well-resourced training institutions, but unique to SAJEI when you compare it with other training institutions like in Kenya, is that SAJEI seems to be intertwined with the department, with the Office of the Chief Justice. And that raises certain questions about how this bill will be implemented. And to latch on to what the Deputy Minister mentioned earlier in his presentation is that there is currently an ongoing transformation process, the institutional and governance arrangements in the judiciary, where the aim is to have a fully independent judiciary in terms of its own institutional independence. There's also a move towards a single judiciary where judges and magistrates are housed under one institution. So those are the things that we have in mind as we were reading this bill. But what we see from the bill does not quite translate to that. And so that's what we are trying to raise in our submission. And then the first topic I'll just get to, and I'll speed through the rest. I know I've spent a bit with the context, but it's important. So the institutional context of SAJEI is that in this legislation, it's meant to be an independent institution, but effectively the SAJEI operates as a branch of the Office of the Chief Justice. The CEO, in the legislation, it's written as director currently, and the bill will change it to executive director. But in all of the documents that we could find, at least the publicly available documents of the SAJEI, it's called, the official is called the CEO. And the CEO on the organizational structure of the OCJ, they are the chief director, and I think they are housed in program 3 of the OCJ, so the judicial education and support aspect of the OCJ. So currently the SAJEI doesn't operate like an entity. If you go to other departments, let's say you go to the Department of Arts and Culture, the Market Theatre is its own entity. It has a council, it has a CEO, it has its own operations. The Artscape Theatre is the same. But when you come to the OCJ, there does seem to be a fusion between the OCJ and SAJEI. So there does seem to be a mismatch between what the Act provides and what is happening on the ground. And this is something will surface because it does raise questions on the text of the bill. And of course, in the OCJ's organogram, we could not find where the SAJEI Council fits, even though we could find where the CEO of SAJEI sits, but we can't see where the Council of SAJEI sits. And that is important on a point that I will come to later about accountability and lines of authority. So just as from what I got from the website of the OCJ, so this is the executive management of the OCJ, and that's where the CEO of the SAJEI sits. Ms. Shamas, I think, is on the call this morning, but yeah, that's where she sits in relation to other officials in the OCJ. And even in the organizational structure that we got from the annual report, you could see that the SAJEI is part of that branch of judicial policy, research, education, and support. And they are in that portfolio. And it does seem to us, at least, that they sit amongst the senior officials in that portfolio. But we're not quite sure how that then aligns with the SAJEI being an independent institution that's supposed to provide training and support and education to the judiciary. Okay, moving on to specifically the role of the dean, which is the major amendment in this bill. So the bill introduces the role of the dean and the role of the executive director, and that comes from a splitting of the role of the CEO. So currently the role of the CEO is both the academic head and the administrative head of the institution. So the bill will split both functions. And so there will be someone who's solely focused on the academic and training program, and the other who will be responsible for the general administration of SAJEI. But the important thing that the bill does not do is what remains about accountability, because the current SAJEI Act, the accounting officer for SAJEI is the Secretary General of the Office of the Chief Justice. So in terms of also, I think the PFMA, the SG is in the accounting officer, I think partly because the SAJEI Act, when it was written in 2008, that bill and its text, it says that the monies for the operations of SAJEI will be taken from the budget vote of the department, at the time it was the Department of Justice. But where it did not clarify is then when that money is defrayed, is it then housed in the SAJEI itself for the council and the executive director to decide how it is spent, or is there a greater role for the SG? And which is why I think we see why the SG remains the accounting officer. Now, there are questions that we thought we should raise with the committee with this arrangement. Number one, will the judge also report to the Secretary General? Because as I explained earlier, in the current arrangement, the CEO of SAJEI reports effectively to the SG. Now, if you're splitting the roles, are you also splitting accountability lines? Are you splitting the authority lines? Does the judge also report to the SG? And that is important because of constitutional principles like judicial independence, and because the dean of the SAJEI will remain a judge. And so will it be that if this bill is passed, a judge reports to a senior official in the government? Is it something that is likely to happen? It's a question that we ask, and we're hoping that our colleagues in the departments will clarify on what that means. And then there's questions about lines of authority. So the bill currently says the dean and the executive director have specific roles and responsibilities, but of course we can see overlap. You can't run an academic program without training materials, without a venue, without getting people to the training venue. And that is obviously the responsibility. One, the academic program is the responsibility of the dean. Getting people to the course is the responsibility of the executive director. One would hope that they work together. But what happens if there is a clash? If the dean says, let's get this training program in the Kruger National Park, and the executive director says, no, that is too expensive. What happens there? In the bill, there's no clarity on lines of authority and lines of accountability. So this is something that we raise, again, as something to think about as you're writing this bill. And then the other issue I mentioned, the questions of separation of powers, the questions of judicial independence, the questions of a move for institutional independence for the judiciary, because one would imagine that if the judiciary is meant to operate independently, its institutions are supposed to fit within that independent operational framework, and specifically SAJEI, because the bill itself, the act as it currently is written, it envisages, but it requires SAJEI to be an independent institution that operates independently. So this is something that we think is worth debating and discussing how this will work in practice. And it's not unique to SAJEI. Similar questions were raised about the JICS judge, so the Judicial Inspectorate for Correctional Services. There was a question there about what are the institutional arrangements when it comes to that entity. There's a similar question about the Hawks judge, and I imagine there would be similar questions about the IDEC judge. But those ones, I think, those are oversight entities as opposed to SAJEI. But the question remains over the reporting lines of a judge reporting to a senior official in the administration. And then going to the executive director as the accounting officer, I mentioned earlier that the current legislation, it says that the Secretary General of the OCJ is the accounting officer for the entity, and the bill will now make executive director as the administrative head. And there are specific responsibilities that they have. Amongst them is the preparation of financial statements, the preparation of an annual report. Now the question is, does the executive director of SAJEI create their own financial statements outside of the OCJ? Do they create their own annual reports outside of the OCJ? How can they if they are not the accounting officer of the entity? These are something that we are bringing up as a question that we are hoping the committee will discuss. And then there's also the move in the legislation in the bill that says that the director, as it's currently written, will now change to be an executive director. We are asking, what is the difference? Is there a substantive difference? The memorandum accompanying the bill does not explain the why. So we are hoping this will be something that will also be asked. And then the next part is the role of the dean. So if you read clause 5 of the bill, it goes at some length on the definition of the dean, and it does refer the definition of the dean to a judge, and the judge is defined in terms of the Judge's Remuneration and Conditions of Employment Act. Now, that definition is obviously useful, but there are practical questions that come up. Number one, the majority of the participants in SAJEI courses are magistrates. The judicial educators, as we understand it, the majority of them that are employed permanently at SAJEI are magistrates, but the dean need to be a judge. Is this an exclusion of magistrates? Does it mean that magistrates are not do not qualify? Well, on the current definition, they do not qualify to be the dean, but the question is, why is that? If the majority of the people you're serving and you're saying that you're moving towards a single judiciary, what is the justification for the exclusion of a magistrate from being a dean? And this is also important because there are other pieces of legislation, such as the Magistrates Act, that speaks about judicial officers, and it's more inclusive to include magistrates. So we wonder why this bill does not also incorporate that language. We are not saying that it is correct, or we're not saying it is wrong, but we're asking why. And then the next part deals with what we propose you should consider as the committee, of course, with respect, that the role of the dean seems to be quite extensive. There are a number of responsibilities there, including running the academic program, running the research program, making sure that you are interacting with judicial leadership at all levels, whether it's the superior courts, it's the regional courts, it's the district courts. There is a responsibility for the dean to interact with them. You also have some foreign relations element, which obviously makes sense, right? Judicial training institutions are global institutions, so you are required to interact with your peers around the world. There's also the part about developing the curriculum and making sure that the curriculum is implemented properly. So it's quite an extensive portfolio of work. And what we see, us being based at the university, there are deputy deans. In fact, at the University of Cape Town, there are 3 deputy deans to assist the dean because of the enormity of the responsibility. So we are putting this forward as a proposal in terms of this specific legislation, and especially because the dean has to interact with judges at different levels, right? I mentioned magistrates, I mentioned judges, I mentioned traditional leaders. So that is quite a portfolio, and so we thought it would be a good idea to have a deputy dean to assist in that responsibility. And then on the second to last topic, which is the accountability lines when it comes to the dean. So as it currently is written, the bill proposes the appointment of a dean on such conditions as the council may determine. That's quite a wide scope. We are not necessarily saying that is wrong, but it is something to ponder on what is the role of the council when it comes to determining the conditions and creating those lines of authority for the dean and also for the executive director. Because if you look at both what the proposed Section 12A and Section 12B, both speak about the appointment of senior officials at SAJEI, and both say on conditions as the council may determine. So we wonder how that will look like, especially because when it comes to the executive director, for example, I mentioned that in practice currently, the executive director or the CEO of SAJEI is by all intents and purposes an official in the OCJ. So we were actually wondering how that would work now when the council is the one that determines their employment conditions, similar to the dean, of course. And then the most important thing that we actually wanted this committee to discuss and debate is on the removal of the dean. So the bill says that you are appointed, if you are a permanent judge, you are appointed for a non-renewable term of 5 years. If you are a retired judge, you can be reappointed for another 5-year term. But what happens if in year 3, the council actually wants to get rid of you because you're not actually fulfilling the responsibilities that are set out in the legislation? Currently, the bill says nothing. There is a silence there on premature termination of the dean's mandate. You basically have to put up with them for the 5 years. And maybe they can have a conversation with him about maybe you can leave early, but it's certainly not written in the legislation. And we wondered maybe it's included in part of the conditions that the council may determine. So it's something that we are hoping this committee will discuss. And then there is quite a clear requirement for the executive director to report to the council on a regular basis on the operations of SAJEI, but there is no similar reporting responsibility for the dean. And we wondered, why is that anomaly? We imagined that accountability should apply across the board, and for us, it really didn't make sense why one senior official is required to account, other not so much. And then, of course, we understand that the dean will remain a judge and subject to the code of conduct for judges. And so we do anticipate that there will be some misconduct that is committed by the dean or possibly committed by the dean during that 5-year tenure that will go to the Judicial Service Commission to process, and the council will not be required to do that. But we're hoping that the bill should clarify lines of accountability, lines of authority very clearly, and especially between the academic head and the administrative head, because the bill does seem to create an equivalence. So how will they work in practice? And then just a quick run through the recommendations that we put forward. Basically, our recommendations can be put together under 4 themes. We want a clarity in function, clarity in authority, clarity in accountability, and clarity in representation. And the 4th one, clarity in representation, what do we mean? The SAJEI is supposed to serve the whole of the judiciary. As the bill is currently written, it creates the role of the dean to be a judge, but we know in practice, SAJEI serves the whole of the judiciary, and the majority of them come from the magistracy. So the representation at that high level, why is it seems to be uneven? It's slanted to one side of the judiciary and not to the other. And then we also want clarity in function in terms of where the SAJEI is and where it sits and what is its relationship with the Office of the Chief Justice. So this is something that we are hoping will be clarified as you write this bill. And then similarly, the lines of authority between the council and the Secretary General of the Office of the Chief Justice, what is their role and functions when it comes to oversight, governance of the institution. We would love some clarity on that. And of course, where the authority lines are for both the dean and the executive director. And the last part is about the portfolio of the dean. We think it's quite large, and a 31 million rand institution. If you look at the MTEF, the budget is going to rise to about 50-something million, and it's quite a large responsibility. We propose that a deputy dean position be created to assist in that portfolio. Chairperson, those are our submissions. We will welcome any comments from the honorable members. Thank you very much.
Thank you very much for your presentation, Mr. Benjamin. We truly appreciate the participation of Judges Matter and the Helen Suzman Foundation, as this was a joint submission. Earlier, I had noted 2 hands. Excuse me. It's actually 3, starting with Honorable Klopa, Honorable Mani, Honorable Tsotetsi. Can I note if are there any further hands? We'll start with Honorable Klopa.
Thank you, Chairperson, and thank you for the opportunity. Thank you for the presentations. Chairperson, so we've established, that what the SAJEI Act wants to achieve, but the submissions made, and that's why I actually asked that the submissions be made, because I've read through them as well, and brings up very, very valid points. I think it was really The presentation confirms that the Executive Director must provide quarterly management reports to the Secretary General. So the first question I would want to know is, can the department and the OCJ just please explain SAJEI's present legal, administrative and financial status, particularly on how its status as a juristic person governed by its council is reconciled with its administration as a component of the OCJ. Chair, I'd also like to know who presently holds the final authority over SAJEI's staff, budget, policy, contracts, operations, the council, the Secretary General, or any other office. Chairperson, in section 13.4, there's an ambiguity of the Principal Act. The provision doesn't clearly name the person or institution responsible for accounting of SAJEI's funds. It may have been intended to refer to the Secretary General, but the present wording doesn't expressly identify the accounting officer or the accounting authority. So who is presently the accounting officer or the accounting authority for SAJEI for the purposes of Public Finance Management Act? And what is the precise statutory basis for this responsibility? Chairperson, I've got lots of questions, but I'm not going to go through all of them. A lot have been asked already, and I do apologize if there is duplication. The bill permits for a serving judge to be appointed as deed on either full-time or part-time basis for non-renewable up to 5 years. And Chair, there should be a caution that the full-time appointment could reduce the judicial capacity, increase the use of acting judges, and add pressure to courts already experiencing the delays and backlogs. We have heard it loud and clear here today from Judges Matters, Mr. Benjamin, about the hefty portfolio this entails, and it's for myself at least concerning how a sitting judge would be able to balance this with the duties that they already have to fulfill. It's been alluded to that there are no deans or deputy deans currently envisioned. How will the judge actually do this balancing trick? Because it seems like it's two really hefty portfolios that they work on their own as a judge, and then that as the dean. What assessments have been conducted of the effect of the appointing of a serving judge as the dean, particularly where the appointment is full-time, on the court's capacities, the judicial vacancies, case backlogs, and the appointments of an acting judge? And what criteria will the council use to decide whether the dean should serve, either then on a full-time or a part-time basis? Why should a preference not ordinarily be given to a judge discharged from active service, as this would be, or at least avoid removing a judge from the adjudication side of, or a serving judge from adjudication? Chair, I'll pause there. I've got many questions, but let me also allow my colleagues to come in. Thank you very much, Chair.
Thank you, Honorable Klopper. Honorable Manyi.
Thank you, Chairperson. I think, firstly, I'm covered with some of the questions that Honorable Klopper has raised. But just going further to that, Chair, based on the presentation, the bill is narrowly focused on creating a judicial dean, redefining the executive director, and adjusting governance and reporting arrangements within the South African Judicial Education Institute. We note this. But for us, as MK Party Chairperson, will focus really on accountability, judicial independence, and measurable outcomes rather than the technical nitty-gritties of the bill. We leave that to Honorable Topper. Chairperson, so I have actually just 3 questions here. The first one really is to say, what problem is this bill actually solving? The presentation explains what the bill changes, but does not demonstrate that the current governance model has failed. Can the department provide evidence that the absence of a dean has negatively affected the quality of judicial education, case backlogs, judicial competence, or public confidence in the judiciary? That's the first thing. Oh, sorry, Chair, I'm recovering from flu here. The second question is, how will judicial independence be protected? We observe that the bill requires a dean to consult with the heads of court and provides for annual reports to be submitted to the minister. So we're not clear how the independence is going to play around those things. What safeguards exist to ensure that neither the executive nor court leadership can influence the academic content, priorities, or independence of judicial education. So the last question on this slot, how will Parliament measure success, Chairperson? Establishing a dean and changing reporting lines will increase administrative responsibilities. What measurable performance indicators will Parliament use over the next 5 years to determine whether these amendments have improved judicial training, reduced delays, enhanced the quality of judgments, or delivered better value for money? So those are the questions related just to the bill, Chairperson. And then based on the department's responses to public submissions on the Judicial Matters Amendment Bill, the three issues for us are as follows. One, failure to strengthen accountability and judicial misconduct processes. The department simply notes concerns that the Judicial Conduct Committee lacks capacity and that Judicial Services Commission Act requires comprehensive reform, promising only a future review. This means Parliament is being asked to pass amendments while the systemic weaknesses remain unresolved. So if the minister was here, we'd be saying everyone agrees that the judicial misconduct system is undercapacitated. No questions about that. But the question is, why is government bringing piecemeal amendments instead of comprehensive reform that will ensure judges accused of misconduct are investigated speedily and transparently? Secondly, on the issue of weak anti-corruption provision for corporate entities, the department refuses to define what constitutes adequate procedures to prevent corruption under the proposed PRECA amendment, arguing that it depends on each entity. For us, we're saying, Chairperson, this creates a legal uncertainty and may lead to inconsistent enforcement. So the question is, if government cannot define what adequate procedures mean, how will business know that they comply? And how will prosecutors consistently enforce the law? Parliament should not legislate vague criminal standards. On the last issue, Chairperson, on the expansion of investigative powers without strong oversight, the bill expands the range of officials who may enforce the Cyber Crimes Act, including municipal police, traffic officers, and border guards. Yet the department rejects the calls for clearer coordination rules and oversight, merely stating that the existing procedures are sufficient. So the issue here for us is that expanding enforcement powers without clear statutory safeguards risks overlapping mandates, abuse, and confusion. Question is, why has the department refused to strengthen accountability mechanisms before extending these powers? That's our submission, Chairperson. Thank you very much.
Thank you very much, Honorable Manyi. Honorable Tsotetsi, please come through.
Thank you very much, Chair. Chair, the presentation by Mbegezeli has covered quite a lot of grounds, and most of the questions posed is questions that we agree with. In light of that, I will just put forward three recommendations and require that in its response, the department deals with the questions as posed. We feel that the bill should be amended to state expressly that the dean is accountable to the council alone in respect of academic functions. Quarterly reporting obligations should flow to the council to ensure governance remains under the judicial leadership. We also wish to recommend, Chair, that it includes the magistracy in the Dean's mandate and amend the definition of Dean and the scope of training functions to include judicial officers generally. That it considers the establishment of the statutory post for Deputy Dean or Deputy Dean to assist with the extensive workload, support succession planning, and serve as a dedicated academic head for the lower court judiciary. As I say, Chair, that most of the issues have been covered quite eloquently by Mbegezeli. Let me pause there with those submissions that I've made. Thank you very much.
Thank you very much, Honorable Totesi. Any other members that I did not see?
Chair, my hand is up. I don't know whether
Yes, please come through.
I'm
Honorable
invisible.
Minister.
I'm like a ghost now.
No, my apologies. I
Honorable
cannot see all hands.
how are you?
Can proceed.
No, I'm just joking.
Noted, Honorable
But,
Mkhala, please
yeah,
proceed.
but my hand has been up. No, thanks so much, Chairperson. The economic freedom fighters appreciate the opportunity to comment on this bill. So, Chair, we support any effort that strengthens the judiciary because our courts play an important role in defending the Constitution, protecting the rights of our people, and ensuring that justice is accessible to everyone. However, Chairperson, Parliament must ensure that every amendment improves accountability, transparency, and transformation within the judiciary. It should not create confusion, duplicate responsibilities, or reduce oversight. So we don't have a problem, Chair, with the intention of this bill, but we believe that several clauses require improvement before the bill is adopted. I think that is the intention for everyone. So when we look at the bill, the general observation is that it's creating a new position of the dean, it renaming the director as an executive director. It's separating academic work from administration. It is clarifying remuneration and reporting arrangements. So in terms of separating academic leadership from administration, I think we really appreciate the intention of the bill. Judges are better placed to lead judicial education than administrators. So, Chairperson, in terms of appointment of the dean, we can see that the bill creates the position of the dean, who must be a judge appointed by council as the academic head of SAJEI. We don't have a problem with that. Judicial education should be led by judges because they understand the challenges faced by the courts. However, the bill does not explain how Parliament can ensure that the appointment process promotes transformation, such as the racial transformation, the gender equality, the youth development, the judicial excellence, and constitutional values. And then when we look again in the clause where it speaks about the dean becoming member of a council, it makes sense that one, Chairperson, a person responsible for judicial education should participate in decisions affecting the institute. However, Parliament must ensure that the council remain balanced and representative. And there's clause 3 and 4 that speaks about the executive director, Chair. The bill changes the title from director to executive director, and makes the executive director responsible for administration while reporting quarterly to the Secretary General. We have a concern there, Chairperson. The clauses raise serious governance questions. The executive director report to the council, the Secretary General, and the minister through annual reports. This creates uncertainty. Who's actually in charge? Can the Secretary General instruct the executive director? Can the council overrule the Secretary General? If there's a disagreement between the Secretary General and the council, who makes the final decision? The bill does not answer those questions. So the reporting lines must always be simplified. Everyone must know who's accountable to whom good governance require clear responsibilities, Chairperson. And lastly, Chair, about the powers of the Dean. The Dean becomes responsible for judicial education, research, training, academic strategy, seminars, curriculum, supervising judicial educators. I think that is a clear a clause in terms of what is being stipulated. But however, the bill should further state that the judicial education must include the transformation, anti-corruption, gender-based violence, customary law, land justice, socio-economic rights, access to justice for poor, and the constitutional values. The judges should actually understand the lived realities of the people, more especially the South African. I think, Chairperson, we are done. I will pause there for now.
Thank you very much, Honorable.
Yes,
Mkhanela.
I'll pause there for now. I think we are done in terms of that. Thanks so much, Chair.
Thank you very much, Honorable Mhlala. Thank you, members, for your participation. Let me join members in thanking Mr. Sibili Mecha as well as Mr. Benjamin for participating in the meeting. Members and colleagues, you will see that the committee actually supports the strengthening of judicial education. Is that your hand, Honorable Mhlala, or is it okay? Can I proceed? Okay, thank you. So as much as we support...
No,
it's a legacy
Chair,
hand.
sorry about that. It's a legacy head, but I see the hand of Honorable Mani is up. Maybe it's Mzwanele who want to speak. Honorable Mzwanele.
Is it a legacy hand?
Apologies.
No problem. Thank you, members. Now, as I was saying, the committee seems to be supporting the strengthening of judicial education because it is a fundamental to an effective justice system. And we believe that a successful SAJEI will have spin-offs of a strengthened constitutional democracy and improved administration of justice. However, the questions raised, as well as the submissions made by Judges Matters and the Helen Suzman Foundation, tries to ensure that the reforms that we adopt do not inadvertently weaken the judicial capacity, create governance uncertainty, or impose unfunded obligations on the office of the Chief Justice. On the issue of imposing unfunded obligations on the office of the Chief Justice, I will have one question just to find out if whether the creation of an additional office, will it not attract the requirement of additional staff, additional resources to support the office, and create a situation where judges might end up enacting roles? And what are the financial implications? Because we may say that the costs are negligible, but is there a particular financial framework that will be followed to ensure that the mandate is funded and there is no undue pressure on the office of the Chief Justice? The second one, I think all members who spoke to it have touched on the multi-roles that the Dean will be performing. The question there is if whether, before the clauses were included in the bill, was there an independent legal opinion sought to ensure that this particular inclusion will be fully compatible with Section 165 of the Constitution and the principle of judicial independence and separation of powers? Because you see, the Dean will also be playing academic, managerial, and administrative functions as well. But as they are serving, they will also be presiding over judicial decisions. The last one from my side is that is just to find out if whether in the creation of the bill, is there an anticipation of the current rapid movements towards greater institutional independence of the judiciary? Or are we likely to have a situation where after the bill is passed or the amendment is concluded and the independent judicial is passed or enacted, we may have to revisit some aspects of the bill to ensure that it complies with a judiciary that is independent? Those will be the three questions. But once again, we appreciate the participation by Judges Matter as well as the Helen Suzman Foundation. It assists in strengthening our objective as a committee to ensure that we pass constitutionally sound amendments that are also sustainable and that they are also funded adequately. And those are the reasons we have these particular questions to the department. I will invite Mr. Sibele Major and any other member of the Ministry of Justice to make inputs and responses to the questions and comments by members.
Chairperson, can I just come in this thing of Helen Suzman being the one that is funding this? You've mentioned something that just touched me. Is there no other organizations that are also allowed to be part of assisting with this thing that we are doing now, more especially with judicial matters? Or is only organization like Helen Suzman and others? Because we are very concerned because of the stance of Helen Suzman sometimes in terms of issues, especially racial issues.
Okay.
So my concern is there no other organization without Helen? We are not saying they are not supposed to be part of this, but it's no other organizations that, because South Africa is a transformed country who also want to participate in issues of judiciary and all those things. Thanks so much. I pause there.
No problem. Thank you, Honorable Msala. No, I think on this matter, the Helen Suzman Foundation and the Judges Matter responded to a call for public inputs. So they came up as stakeholders who have interest to make a view and participate in the process of lawmaking. So I believe that other institutions and stakeholders who may have interest in the process of legislation and amendments are at liberty to reach out and make presentations and also request a platform to present in person, like what Honorable or Mr. Benjamin rather has done. So it's not that they are actively involved in amending the bill. They are responding to the submissions by the department to say these are the areas that we are focusing on when we bring these amendments to the bill. So any other stakeholder is allowed to participate. Mr. Sibele Major and the team.
Yes, thank you, Chair. I would attempt to respond, maybe with the caveat that as you would know, usually the presentations for the briefing are done separately from the submissions. And when we respond to the submissions, we normally would engage internally. We'll prepare draft responses, then we engage internally and also consult the body from which the proposed amendments will be emanating from. So I'm a bit constrained in terms of saying things that I would not have discussed with the broader family within the justice. And as we indicated that some of the changes emanate from the council itself. But let me just attempt to clarify some of the things that says when we provide the proper responses to all of the submissions that have been made, we'll deal with all the issues. But firstly, as indicated, the bill was merely dealing with the issues of the roles and functions. And coupled with that, going to the issue of the deputy dean, is that when we first drafted this bill comes, I think we should have introduced it before in the last administration, but then we had an issue with the issues of finances in terms of the funding, which we needed guarantee that the OCJ had as properly budgeted for. And I think that engaged Treasury, and Treasury then had made an allocation for the year 2025-2026, which then allowed us to proceed to process the bill further. And now with the addition of the Deputy Dean, of course, the question that Chair also raised will then have to then engage in terms of the financial implications thereof, which we'll properly consult on. And then secondly, the issue of the accountability. Yes, I think the suggestions that have been made are appreciated, and I think that's one thing that would want to be clarified. However, just to mention that with the process of the independence of the judiciary, we are already prepared a draft bill which will deal with some of the issues on accountability, which we are grappling with and have raised as concerns in respect of the how currently some of the things are run and the bodies within the OCJ are run, and with the Chief Justice being one of those that is heading some of the bodies, and we foresee a bit of some challenges in respect of accountability and reporting. So with that, I would say we would want to further discuss the issues and straighten them out. And secondly, that the process, as Chair correctly from my point of view indicated, that would this process not have the likelihood that when the bill that deals wholly with the independence of the judiciary, would it not necessitate amendments in terms of accountability and reporting lines? Yes, that's already on the table for us internally, that some of the things would have to be clarified in terms of accountability, knowing that we would have dealt with the bill on how we'd want to see the judiciary leading itself as the third properly arm in terms of administration as well, everything, but also reporting lines and accountability also included towards Parliament. So those are the things that if we are going to raise them, and also would, for example, the bill might also want to amend some of the current legislation that would clarify the reporting and accountability lines. So the likelihood is there, we've already picked it up, that the issues of accountability would need to be clarified going forward. And I think, Chair, with the risk that I indicated that I would not want to have my personal views raised on the submissions that have been made, I would kindly request that we be given an opportunity to go prepare the draft responses in detail, and then we'll then canvass them with the principals and also consult the council in respect of the responses that we'll make. And I think I'm just constrained by that today we've dealt with two processes that we normally and ordinarily deal with them separately. Thank you, Chair. I hope that my request is appreciated and granted. Thank you.
It is granted, Ntate Sibile Mecha. We will then, as a committee, invite you to come and respond to public submissions at a later stage. However, Mr. Benjamin is at liberty to respond to the inputs that are made by members as a reflection, if there is a need to do so, or if there are areas that he believes that requires clarification, or maybe to further emphasize as per the comments of members. Mr. Benjamin, are you content? Are you happy? Would you like to come in?
Thank you very much, Chairperson, and thank you very much to the honorable members. I think a lot of the questions that honorable members and the inputs that the honorable members shared, Mr. Sibile Mecha said that he will respond to at a later stage. So I'd like for now to reserve our input, and then we'll wait for Mr. Sibile Mecha and the colleagues at the DOJ and OCJ to come back, and then we can then take up our opportunity.
That is in order. Thank you very much, Mr. Benjamin. No, we'll proceed in that fashion, Mr. Sibilimecha, that at a later stage you will be coming back to the committee so that you are able to then respond fully to the public submissions that are made. And those questions that you believe members have put forward but still require a collective processing in the department so that you don't speak alone and try to represent the collective's view. So we'll allow that process to unfold in that particular fashion. Members and colleagues, having exhausted item 4, which is the last item, let me take this opportunity to thank you for joining the meeting and your participation. The committee will be sitting again tomorrow at 9:30 on the Zoom platform, and there we will be receiving a briefing on the international cooperation in criminal matters amendment bill, and also receiving responses by the department on the judicial matters amendment bill. See you tomorrow at 9:30. Thank you very much. The meeting is adjourned.
Chair.
Thanks so much, Chairperson.
Don't
Chairperson.
leave the chair.
Thank you.
Mara,
Honorable Mshala, Wabulel.
no ke re ka re meeting e dula o sa tshwenya gore ke tla ba ke ya go rona mathafa. Mr. Benjamin ba santse ba fetola ba re botsa gore ba yo kopana ke moka ba tle ba re fetola. Why ba sa le teng here so that we don't have a situation like that one?
Oh, no, Mr. Benjamin yena
Je
akere
ba
yena.
e bolela re le ka moka because a ke re meeting o adjournile ke nya go tseba gore go dira ke eng ntho o tshwana le eo.
A ke Mr. Sibilemacha wa bolela gore ana dikarabo for tse dingwe ka hobane di batla makala a mangwe a department. So o tla re ge ba kopane o tla tlisa dikarabo tse di felletseng. Mr. Benjamin o re le botsisa di-question tse maleba. So o tla emela department e tle e arabe ka nako e tlang, and then o tla participate gape go ya ko pele. Mara o dumelana le lona.
Oh, okay, no sure.
Re a leboga.
Thanks so much. Okay, re a leboga.
Thank you very much.
Thanks.